Welcome back to the Friday Five for January 26th, 2024. My name is Andrew Ayers. I'm a business law and estate planning attorney with offices in Edina, Minnesota and New York City. On Fridays, we look at 5 quick questions that came up this week. We do it in about 5 minutes, FAQ style. Maybe these are questions you've had before in the past. Question number 1 this week: how many LLCs do I need to set up for my rental property? So in this case, the prospective client actually owns a few different rental properties. For now, those properties are still in their individual name, and they're looking forward to moving those properties into an LLC. The question was, how many LLCs do we need? So if we have 3 rental properties, do we need to set up 3 LLCs? Do we need 1 LLC to hold them all? Is there something else? And so what we talked about is there's 2 different scenarios we can look at. One scenario is we're going to have everything put together in the perfect plan for us. And in that case, what we will normally do is create a trust, and we'll have an LLC that's a holding company, and then have those real estate LLCs under the holding company. And I want to have 1 LLC per property. And what that does is limit the liability of each LLC to the property value. So if we have 3 properties in an LLC and one of the properties is sued, the problem is the assets of those other 2 properties are technically assets of the LLC that would be subject to that lawsuit. So what we want to do, if possible, is create 1 LLC for each property, and then in many cases create a holding LLC for when we have a variety of rental properties. In this case, however, the client doesn't have unlimited funds, and so what we're looking at is some kind of a hybrid approach between those 2 to sort out what's the best way to protect their assets. Question 2 this week: do I need to set up another LLC, or can I use the one I've got already? So this was a similar caller, although earlier in the week, and this one has rental properties as well that we're going to put into an LLC. But this caller actually also already has an LLC with other investors in other matters. So they have their own business that's running other rental properties. And the question was, do we need to do a new LLC, or can we use the existing one? And in this case, we're going to do a new LLC because he does not want the partners in that other venture to have any interest in the properties we're going to set up next. So although you may already have an LLC, that doesn't mean you have to use it for all of your business transactions. There's a lot of times it's going to make sense that we create a separate LLC, especially when you don't want to bring in partners from a different business into a new business that you're starting. Question 3 this week: can I bring my lawsuit in federal court? So this was an interesting call with somebody who really has a state court claim. So they've done some research online, and you can see the different ways that you can get into federal court, primarily if there's a federal question, meaning a constitutional law question, or we're challenging a federal statute, or if you have citizens of different states and at least $75,000 in controversy, meaning the lawsuit is worth at least $75,000. In this case, however, the parties were both in the same state, and there really would be no federal jurisdiction here, even if we took the damages way above $75,000. In this case, the caller was trying to find some kind of way to get into federal court, thinking that federal court would give them a better outcome. And while if you read online, you can get a lot of information about federal court versus state court and how the cases are managed, and people will tell you that federal court's always the better way to go, you have to remember that federal court is a court that's constantly looking to find a reason for you not to be in federal court and to remand you to state court or some other court. So just because you think federal court might be the right court for you doesn't mean the case would actually stay there. Question 4 this week: can I access bank records with a power of attorney? In this case, a son had a power of attorney for his mother, and the mother's bank accounts were showing some weird transactions and some other transfers that the mother was not aware of. And the question from the son was, I have a power of attorney from my mother. Can I use it to get access to bank records? In most cases, the answer to this will be yes. But what you need to do is look at the power of attorney itself and see what powers it grants you. So when we create a financial power of attorney, there's usually 2 ways we can do it. One way is a limited power of attorney, where the power of attorney is granted for like a real estate transaction, just for banking, just for a stock sale, just for a business. And the second way you can do it is giving a blanket authorization, meaning I'm giving you power over all these different types of matters in my life, all these different legal and financial matters. I'm giving you that power. So what you need to do is look at the power of attorney document itself and make sure you understand what powers were granted to you. And then if you want to go to the bank, if you've got that power, you'll need to bring the original power of attorney with you to show to the banker, and they'll probably want to make a copy and keep it in their file. Question 5 this week: does my investment account have to go through the probate court? And the answer on this one is it does not have to. Many times it will, however, if you don't have a beneficiary designation on it or you don't jointly own the account with somebody else. So if at the time of your death you have an investment account that you own jointly with somebody else, most of those accounts will be held jointly with a right of survivorship, meaning that when one of you dies, the other one can continue to hold the account. However, many investment accounts also allow you to do a beneficiary designation. And in these situations, that beneficiary designation is actually going to take priority for distribution over a will, meaning that even if you put in your will that you have to distribute all your accounts, the probate court doesn't necessarily have to be involved with those distributions. If you use the beneficiary designation, then when you've passed on, that investment account can be transferred directly by a beneficiary designation. And this is the preferred way to do it. We want to keep assets out of probate court where we can. So if you have an investment account and you're not sure about this, talk to your financial advisor, talk to the bank where the investments are held, and find out whether there is a beneficiary designation. And if there isn't, can you add one to the account? Those are 5 questions for this week. If you liked the video, you can hit the like or the thumbs up button below. You can subscribe for future episodes on YouTube. You can submit a question for future episodes in the link below. You can always go to my website, 𝙃𝙀𝙍𝙀𝙒, for more information or to set up a legal strategy session. And wherever you are, I hope you have a wonderful weekend.